The respondents had challenged their above mentioned conviction and sentence by way of an appeal before the learned additional session judge. Full stop. During pendency of the appeal, the respondents had moved the above mentioned applications, whereby they had requested for bringing on the record a report of the district standing medical board. Full stop. The learned appellate court, through the order in question, had accepted the above mentioned applications and request made therein, and consequently, while setting aside the above said judgment of the learned trial court, remanded the case with a direction to record the additional evidence and decide it afresh. Full stop. It is evident that for additional evidence, the above mentioned procedure should be adopted, and in no case the said practice, chosen by the appellate court, could be recommended and approved. Full stop. On realizing the situation, the learned law officer in attendance as well as counsel for the respondents have frankly held the order in question to be a patent illegality. Full stop. Resultantly, the findings of the appellate court made in the impugned order regarding setting aside of conviction of the respondents being totally unjustified and against the procedure are turned down. Full stop. However, as the document intended to be brought on the record is public record, surely beneficial to reach at just conclusion, therefore, the above said applications have rightly been allowed. Full stop. Consequently, it is directed that the learned trial court shall record additional evidence sought through the above said applications and transmit the same to the appellate court. Full stop.